Hello, it's Phillip Taylor speaking from Richmond Green Chambers. I'm looking at a book from Jordan's, which is a new one. It's this one here. It's a heavy book. It's on costs, civil costs, law and procedure by Dr Mark Friston. It's the first edition, 1200 pages. It's got a great deal in it, as you can see. It's a very erudite book. It covers just about every single aspect you can think of. I found the index at the back very helpful, right at the back. And the thing that really does help is that particular thing, if you can see it on the back page, inside cover. Do plasticate, but I mentioned this in the review. The book is heavy, and I'm just wondering whether it will fall to pieces quite quickly if it's used a lot. But my view is it's an excellent new addition to the costs library. This is what I say about it. I've written it with my wife, this review, and it's called Explaining the Cost of It All. As I've indicated, it's a brand new edition by Dr Friston, which offers a breath of fresh air over costs orders, with what he rightly describes as a paradox, in that it can be both emotive and outstandingly dull. And certainly it is from the many cases I've been involved in involving costs. Oh no, you think, we don't have to deal with costs again, do we? Well, yes we do, every time. And Friston gives us the details in one paperback volume. As I've said, this is most important at the back on CFAs, but do plasticate the cover if you want to keep it, because I think it'll get a bit damaged quite quickly. So in the 1200 odd pages and the 41 chapters, this authoritative and comprehensive work ranks highly in our view with the most well-known annual, which is Cook on Costs. The difference between Michael Cook and Mark Friston is primarily one of opinion and style, although we feel the Friston content is greater because his book is longer and heavier. But you haven't got Michael Cook's rather interesting commentaries. One important aspect which differs from other works in this area is that there are references to many authorities, and I think that's a very helpful thing for us, because it saves you having to cross-refer to a whole range of different publications. Friston's aim is to provide a practitioner's text which is focused solely on the law rather than policy, i.e. Michael Cook, and which is detailed and fully referenced, where the author avoids expressing his own views on policy unless they're uncontentious. Bit of a pity in some ways if you're in the Court of Appeal, because you might be wanting to put forward a particular line of thought, and sometimes the policy issues are quite important. The book covers what Friston calls 4 species of lawyer: cost practitioners, solicitors, DJs, and counsel and solicitors with higher rights. We advise those undertaking training or those who've recently qualified to use this book, because it's got a wealth of general common sense about how to operate in the court environment when it comes to costs. And I suggest you look particularly at chapter 31 on counsel's fees, very relevant to people like myself, and fixed costs in the small claim track and the fast track. Can I just say that obviously public access is just coming in for barristers, so costs could have implications there, and also the whole concept of whether barristers have contracts. Again, that is a subject which will be looked into, and clearly the current advice given here is very helpful, but we all expect substantial change in the next 18 months. In conclusion, I would say that Friston on Costs, as I would call it, is a worthy work, and his approach fits in nicely with the established books that we currently have on costs, making it a one-stop shop for the law governing civil costs, from the lowest court to the highest court, so advocates do not go into the judicial argument unprotected if they have civil costs with them. Thank you very much to the author for a huge amount of work, and to Jordan's for publishing it. Bye bye.